All right, today we're diving deep into negligence law, specifically something called causation.
Okay.
And I guess in plain English, we're trying to figure out how to prove legally that somebody's mistake actually caused harm.
Right.
So you sent over a whole bunch of articles and court cases, some really fascinating stuff,
Yeah,
ready to kind of break it down.
absolutely. And I think you'll find it's a lot trickier than it might seem at first.
Okay.
It's not just, kind of a common sense, this happened because of that sort of thing.
Right.
There are specific legal tests
Yeah.
to determine both what we call factual and legal causation. And they're two sides of the same coin when it comes to actually proving negligence.
So it's not enough to just say, well, obviously this led to that. We
Right.
need to prove it legally.
Exactly. You have to establish a really clear link between a breach of someone's duty of care
Hmm.
and the harm that was suffered because of that breach.
Okay, that makes sense.
Yeah.
So I see we have a lot of cases here.
Yeah.
And I know one of the big ones is this but-for test.
Yes.
Help me understand that one because it sounds pretty straightforward,
It does.
but I'm sure it's a lot more complicated than that.
Yeah, it can get pretty complicated, definitely.
Right.
The but-for test basically asks, but for the defendant's actions, would the harm have happened?
Right.
If the answer is no, then you've established what we call factual causation.
Okay, so give me like a really simple example then. Like if I spill coffee on someone and they get burned, but for my clumsiness, they wouldn't have been burned.
Right.
So open and shut.
Yeah, probably in that scenario, yes.
Okay.
But let's look at a case where it gets a little trickier.
Okay.
This case is called Barnett v. Kensington and Chelsea Hospital Management Committee.
All right.
And this one's a real tragedy.
Okay.
3 men drank tea that was laced with arsenic.
Oh, wow. That's terrible.
It is.
So I'm assuming they went to the hospital?
They did, but the doctor on duty didn't actually examine them. He just advised them through a nurse to go home and call their own doctors.
Okay.
And one of the men, Mr. Barnett, sadly died.
Oh, no. So that seems like, clearly a breach of duty by the hospital there.
You would think so, yeah.
Yeah.
But the court ultimately decided that the hospital wasn't liable for Mr. Barnett's death.
Really?
Yeah, and the reasoning behind that was that even if the doctor had seen him right away,
Right.
he likely still would have died.
Okay.
Arsenic poisoning is so rare
Yeah.
that the hospital probably wouldn't have had the antidote on hand.
So, but for the doctor's inaction, the outcome probably would have been the same.
Sadly, yeah, in this case, it probably would have been.
That's interesting.
Yeah,
So the but-for test seems pretty straightforward, but like you said, it can get a little tricky.
definitely.
And it doesn't always lead to what I guess we might consider a fair or just outcome.
It does raise those questions, doesn't it?
Yeah.
About how we actually determine responsibility
Right.
when a negative outcome might have happened anyway.
That's a really good point. And, it makes you wonder if sometimes the but-for test is maybe too rigid, right?
Yeah, it's a very black and white test in some ways.
Yeah.
The law is often dealing with very gray areas,
Yeah.
so there are definitely some issues there.
What about those situations where there are multiple potential causes of
Mhm.
harm, right? Like more than one person or more than one factor kind of contributing to the problem?
Mm-hmm.
Imagining those cases get really messy.
They do. They definitely can.
Okay.
Let's take the case of Bonington Castings Ltd v. Wardlow as an example.
All right.
In this case, an employee developed a lung disease from inhaling silica dust at work.
Okay.
It was pretty clear that the employer was negligent in this case.
Right, because the employer has a duty to provide like a safe work environment, right?
Absolutely, yes.
Okay.
However, it's important to note that the employee would have inhaled some silica dust anyway
Yeah.
as part of his job.
Right, just by the nature of the work.
Exactly, yeah.
Ab-
So the legal question then becomes, did that extra dust, due to the employer's negligence, make a difference in causing the disease?
So it's not just a simple yes or no, like, did they inhale it?
Right.
It's, did the extra amount that they inhaled because of the employer's negligence actually cause the disease?
Exactly, and how do you untangle that?
Yeah, so how did the court approach that?
Well, in this case, the court found that because the employer's negligence materially contributed to the employee's disease,
Okay.
they were liable for the full extent of the harm.
So it wasn't about proving like a specific amount. It was just
Mhm.
that they contributed to it.
That their actions made a bad situation worse. Yeah.
So if your actions make the situation worse,
Right.
you're held responsible
In essence, yes.
for the consequences.
But then we have another case, McGee v. National Coal Board,
Really?
which adds another layer of complexity to this whole idea.
Okay.
This case involved dermatitis caused by brick dust. And again, some exposure to this dust was unavoidable, just part of the job.
Right.
But the employer failed to provide washing facilities.
Okay, so now the question becomes, did that lack of washing facilities actually cause the dermatitis,
Yeah.
even though he was exposed anyway?
Right.
That seems really hard to prove.
It is. It's very hard to prove definitively.
Yeah.
And this is where this idea of material increase in risk comes into play.
Okay.
The court in McGee decided that even though you couldn't directly prove
Right.
that lack of washing facilities caused the dermatitis,
Yeah.
the employer's negligence significantly increased the risk of that harm.
Interesting.
And that was enough to establish causation.
So sometimes it's not about proving like a direct link.
Right.
It's showing that your actions made a bad outcome more likely to happen.
Yes, exactly.
Right.
That's a very key distinction in negligence law,
Right.
but it's not always applied consistently.
Oh, of course not. This is law we're talking about.
Exactly, yeah. There's a case, Wilshire v. Essex Area Health Authority, where a baby was given too much oxygen,
Okay.
which is a potential cause of blindness.
Okay.
However, there were other potential causes as well.
So multiple possibilities again.
Multiple possibilities, exactly.
Did they go with that same material increase in risk argument here?
Actually, they didn't. They went back to a more stricter but-for approach in this case
Okay.
because there were multiple potential causes.
Right.
You couldn't say definitively that the excess oxygen was the cause of the baby's blindness.
Yeah, that makes sense.
But again, it's a case that's debated a lot.
Yeah, I can see how somebody could argue that even if it wasn't the only cause, it still increased the risk.
Exactly.
Right.
Exactly. So, yeah, it raises a lot of questions about, like, how do we weigh these different things
Mm-hmm.
when we're trying to figure out what caused something?
And that question becomes even more complex, I think, when we start looking at cases involving mesothelioma.
Right. And I know, like, from what I understand, even a single asbestos fiber,
Can lead to mesothelioma years later.
Right.
Nice.
right,
So how do you prove which exposure actually caused it?
it's almost impossible.
Right, because if you worked for, like, multiple employers
Yes.
and they all exposed you to asbestos,
Right.
how do you prove which one was the culprit?
It's a significant legal hurdle,
Yeah.
and that's where the landmark case Fairchild v. Glenhaven Funeral Services comes in.
Okay.
This case set a precedent for these mesothelioma cases.
Right.
And what the court decided
Yeah.
was that if it's impossible to prove which employer
Uh-huh.
was responsible for the guilty fiber, so to speak,
Right.
then all employers who negligently exposed the person to asbestos would be liable.
Wow. So even though it could have been just one of them,
Right.
they all have to kind of share the responsibility.
Yeah, I'll have to share the responsibility.
That's a huge
It
decision.
was a huge decision.
Yeah.
And I think it highlights how the law sometimes has to adapt
Right.
to situations where the traditional causation tests
Yeah.
just don't really provide a just outcome,
Yeah.
especially in cases where, science can't give us a definitive answer.
Yeah. It makes you realize, I guess, that there's a human element to a lot of these decisions too, right?
Absolutely.
Like, it's not just about the law.
It's not just about ticking boxes and,
Yeah.
legal tests.
There's this need to try to balance it with fairness.
Right.
And I think especially in cases like these that have really devastating consequences,
Yeah.
it's not just a theoretical legal argument.
No, these are real people's lives.
Yeah, exactly.
Yeah.
Okay, so we've got multiple potential causes. We've got these but-for situations. What happens if someone suffers multiple injuries over time
Right.
and potentially from different sources?
Yes.
Right. So, like, what if somebody is injured in a car accident
Mm-hmm.
and then they have a totally unrelated injury, a few years later?
Yeah.
Does the driver from the first accident
Right.
have to pay for all the ongoing problems?
Well, that's an interesting question, and I think you can see arguments on both sides.
Yeah, right.
And it really would depend on whether that second injury made the first one worse.
Right. Okay.
So let's look at two cases that illustrate this.
Okay.
The first one is Baker v. Willoughby. And in this case, someone was injured in a car accident.
Okay.
And then years later, get this,
What?
shot in the same leg.
Wait, shot.
Shot.
That's a wild turn of events.
It is, yeah.
Okay.
So the defendant in this case argued they should only be liable for the car accident injuries,
Right.
not anything that happened after the shooting.
Yeah, that makes sense because it seems like that's totally separate.
Right.
What did the court say?
Well, The court decided that the original negligence from the car accident continued even after the shooting.
Wow. So they're saying that even though there was a separate event,
Hmm.
they're still responsible for the initial harm.
Yes. And the argument there was that the initial injuries were still present
Okay.
and still impacting the person's life, even with this new, more severe injury.
That's fascinating.
It is, yeah.
So does that always apply, though?
Well, let's look at another case.
Okay.
This is Jobling v. Associated Dairies.
Right.
And this time, we have a back injury at work,
Okay.
followed by an unrelated back disease.
Oh.
So the question here is, does the employer have to pay for the ongoing back problems even after this unrelated disease developed?
Well, it seems kind of unfair, right?
Yeah.
To hold the employer accountable
Yeah.
for a disease they didn't cause.
And the court agreed.
Okay.
They ruled that the employer was only liable for damages up to the point the disease developed.
Hmm.
They considered this disease what they called a vicissitude of life,
Okay.
essentially an unfortunate but naturally occurring event
Right.
that essentially worsened the initial injury.
So they basically drew a line and said,
Good drew a line, yeah.
up to this point, it's your responsibility.
Right.
After this point, it's just bad luck.
Yes, basically.
Wow, that's interesting.
Yeah. And so these two contrasting cases
Yeah.
really show how courts can kind of grapple with these multiple sufficient causes
Right.
when they're trying to determine liability.
Like a constant balancing act.
It is a constant
Yeah.
balancing act.
Yeah.
Yeah, they have to weigh, things like foreseeability,
Mm-hmm.
the nature of that subsequent event,
Right.
and the overall fairness
Yeah.
of holding someone responsible for something that might be partially attributable to something completely outside their control.
Yeah, I mean, it's making me think about how tricky it can be to even define what caused something, right?
Exactly.
Because it's not always black and white.
It is not black and white, no.
Especially when you get these really complex scenarios with multiple factors at play.
Exactly.
Okay, so we've talked about multiple causes. We've talked about the but-for test, but what about situations where it's not even a physical action that
Right.
leads to harm, but rather a lack of information?
Yeah, that's where we get into this whole concept of failure to inform.
Right, and I'm thinking, like, medical cases, you know?
Exactly. That's a classic example.
Like where a doctor doesn't tell a patient about all the risks of a procedure.
Right.
If something goes wrong, is it their fault, even if the procedure itself wasn't done negligently?
That's the core issue in these cases.
Right.
The question becomes, would the patient have consented to the procedure if they had been fully informed of the risks? If the answer is no,
Right.
then the doctor's failure to inform could be considered the cause of the harm.
It's like, if you don't have all the information, you can't really make a decision, can you?
You can't make a truly informed decision.
Right, and that lack of information could lead you down a path that you wouldn't have chosen otherwise.
Exactly.
Are there any cases that kind of illustrate this?
Oh, there were some significant ones.
Okay.
Chester v. Akshar is a
Yeah.
key example.
All right.
In this case, a surgeon failed to warn a patient about a small risk of a very serious spinal condition that was associated with the surgery. The patient went ahead and had the surgery,
Right.
developed this condition,
Oh.
and the court had to decide if the doctor's failure to inform was the cause,
Right.
even though the surgery itself wasn't performed negligently.
That seems like a tough call.
It is a tough call.
Because on one hand, the risk was small.
Right.
On the other hand, they weren't given all the information they needed to really decide.
Yeah.
What did the court decide?
The House of Lords ultimately ruled in favor of the patient in this case.
Wow.
They really emphasized the importance of informed consent
Right.
and the doctor's duty to inform patients of all material risks,
Even if they're small.
even if they're small.
So it's kind of like saying you have the right to know what you're getting into,
Exactly.
even if the odds are in your favor.
Yeah, no more doctor knows best, so to speak.
Right.
Patients have a say.
Patients have a say in what happens to their own bodies.
Precisely.
Okay, that's huge.
Yeah.
And was that kind of reinforced in any other cases?
It was, this concept of informed consent
Okay.
was reinforced in another very important case,
Go.
Montgomery v. Lanarkshire Health Board.
Right.
And in this case, it was even more, I guess you could say, egregious, because the doctor deliberately withheld information
Okay.
about the risks of vaginal birth for a woman with diabetes.
Wow.
complications arose,
Right.
leading to a severely disabled child.
Okay, that's even more troubling than the last case because they actively chose not to share information.
Exactly.
Right.
Exactly.
So what happened in that case?
Well, this case really became a landmark case
Okay.
and solidified this shift in legal thinking about patient autonomy.
Okay.
The court stated that patients must be treated as capable individuals
Right.
who can understand and weigh risks,
Right.
not just passive recipients of medical care.
Yeah.
So it was really highlighting how withholding information can directly cause harm,
Right.
even if the doctor doesn't directly cause the physical injury.
Right. It's such a powerful statement about, knowledge and having the right to know what's happening to your own body,
Absolutely.
the right to make choices.
Mm-hmm.
It really brings home how causation can go beyond, like I said, just physical actions.
Yeah.
It can be about information. It can be about choice.
It can even be about power dynamics
Exact.
between, doctors and patients in this case.
Right. And how that can actually cause harm.
Absolutely.
Wow.
So that brings us to another really interesting aspect of causation.
Okay.
This idea of loss of chance.
Yeah, that's where things I think really start to get interesting.
Right? It's very complicated.
Because we're not talking about like being harmed directly.
Yeah.
We're talking about losing the chance to avoid harm.
That's exactly right.
So how do you even prove that?
Well, that's the challenge, isn't it?
Right?
It's a very debated area of law.
Right.
It's about recognizing harm that isn't a certainty, but a lost opportunity, a chance to avoid something bad happening.
Okay, so let's get into that. But first, I think we need to take a quick break.
Sounds good.
Okay, so we're talking about this idea of loss of chance,
Right.
which you said is a really tricky area of the law.
It is.
So how do you even begin to prove that you lost a chance?
Yeah.
Especially if the outcome, was never guaranteed in the first place.
Exactly. And I think that's one of the things that makes it so debated.
Yeah.
It's not about, a certainty.
Right.
It's about a lost opportunity,
Okay.
a chance to avoid something negative.
Hmm.
So let's take a look at the case of Hodson v. East Berkshire Health Authority
Okay.
to kind of illustrate this. It involves a young boy who fell from a tree and injured his hip.
Ouch. Falls from trees are never good.
No, they're not.
So what happened?
So the doctor misdiagnosed this hip injury, which led to a delay in proper treatment.
Okay.
And as a result of this delay, the boy developed a condition called a vascular necrosis,
Okay.
which ultimately caused paralysis. Yeah, so the argument was that this misdiagnosis essentially cost him the chance of avoiding paralysis.
Right, but how do you prove that?
Right, and that's the challenge.
It's not like they can go back in time and see what would happened with the right diagnosis.
Exactly. It's all about probabilities,
Okay.
not certainties.
So in Hodson, was there expert evidence presented about what those probabilities might have been?
There was. And in this case, the expert evidence suggested that even with a correct and timely diagnosis,
Okay.
there was still a 75% chance that the boy would have developed a vascular necrosis and paralysis.
Wow, so only a 25% chance that it could have been avoided.
Right?
So did the court consider that lost 25% chance enough to establish causation?
Sadly for the boy, they didn't.
Oh, wow.
The House of Lords, sticking to that but-for test, reasoned that because paralysis was more likely than not to happen anyway,
Right.
the doctor's negligence wasn't the cause.
So it's like saying, well, the odds were already stacked against you, so we're not going to hold anyone responsible for making them even worse.
Yeah, and that's why this is such a controversial area of law.
Yeah.
Because Hodson is a case that is cited a lot.
Yeah.
When people debate whether the but-for test really adequately addresses these situations,
Right.
it raises these questions about how we value a chance, even a small one,
Mm.
and whether losing that chance should be considered a harm in itself.
Yeah, I can see both sides.
Mm-hmm.
I mean, it seems incredibly harsh, but then at the same time, it's hard to prove a negative, right?
It is.
Like, how do you prove that something wouldn't have happened?
It's almost impossible, and that's why these loss of chance cases are so difficult.
And I know there's another case
Yes.
that kind of fuels this debate even further, right?
There is Greg v. Scott.
Greg v. Scott, okay.
This time, we're dealing with a misdiagnosed cancerous lump,
Okay.
which led to a delay in treatment.
Yeah, any delay in cancer treatment is just, terrifying.
It is. It's terrifying.
So did the patient here argue that this delay essentially cost him a chance of survival?
He did.
Okay, and I'm guessing, with the last case, statistics probably played a role here, right?
Statistics did play a big role here, yes.
So what were the numbers like in Greg v. Scott?
Well, he had a 42% chance of survival at the time of the misdiagnosis.
Okay.
But because of the delay, his chances dropped to 25%.
That's a huge decrease.
It is a significant decrease.
But I'm noticing a pattern here.
Yes,
Even with the delay, his chances were still less than 50%.
that's right.
Did the court rule in his favor?
No, they did not.
Wow.
The House of Lords, again upholding that but-for test, reasoned that because the patient's chance of survival was already below 50%, the doctor's negligence couldn't be said to have caused the reduction.
It's so heartbreaking to think that, like, a misdiagnosis and a delay in treatment could essentially be dismissed like that, even if it wasn't, guaranteed that he was going to survive anyway.
And that's why this whole area is so debated.
Yeah.
Because people argue that it doesn't adequately address these situations.
Right.
And it highlights how difficult it is to apply these traditional causation tests to cases where the harm is really based on probability rather than certainty.
Right. It's not like a broken leg.
Exactly.
It's much more nuanced.
Exactly. And some legal scholars would say that loss of chance should be its own type of harm.
Okay.
That it should be recognized regardless of those initial odds.
It makes you wonder how much of this is just like the legal system trying to catch up with, scientific advances in our understanding of things like probability.
Yeah, I think that's a really good point.
Right, because, especially in medicine, we're getting better and better at calculating risks and chances of survival and all these kinds of things.
Absolutely.
But the law seems to be a bit behind.
Well, the law is often reactive, right? It has to respond to these developments.
Yeah.
I think that's part of what we're seeing here.
It's like it's struggling to keep up with these increasingly complex situations.
Exactly.
Yeah, it raises some really fundamental questions about how we value a chance, especially in these medical contexts.
Yeah.
And what level of responsibility healthcare providers should have for these missed opportunities, even if, again, they can't be definitively linked to a bad outcome.
It's a very gray area.
It's very gray. It's not black and white.
It's not.
And I think, it goes beyond just the law.
Absolutely.
Right. It's these ethical considerations about patient rights and, the value of even a small chance.
Even the smallest chance.
Of recovery.
Yeah.
It's a lot to unpack.
It is. It is.
Okay, so we've talked about factual causation, right? We've talked about loss of chance.
Yeah.
What about this idea of legal causation?
Right. So even if we've proven that someone's actions were the factual cause of the harm, we still need to consider whether that harm was too remote from those actions.
So it can't be like a ridiculously long chain of events.
Exactly.
Where the connection is just way too weak.
Yeah, it can't be too far-fetched. It can't be too unpredictable.
Right.
There has to be some reasonable connection
Okay.
between the action and the harm.
Yeah.
So it's like, okay, you spilled the milk, but are you really responsible for the chain reaction that led to someone tripping, bumping their head, and missing their flight to, like, their dream vacation?
That's a great analogy.
Right.
Yeah.
Okay, so is there, like, a test for that, too?
There is. There is a famous test for this.
Okay.
And it's called the Wagon Mound test.
The Wagon Mound test. Okay, I like that. A test named after a case.
I know, right?
So what was so special about the Wagon Mound?
Well, the Wagon Mound actually comes from a case called Overseas Tank Ship, UK, LTDV Morts Dock and Engineering Co.
Oh, wow. That's a mouthful. It is a mouthful, which is why everyone calls it the Wagon Mound.
The Wagon Mound, okay.
So this case involved a ship, obviously, called the Wagon Mound, and it was docked in Sydney Harbor.
Okay.
Due to negligence, it leaked oil into the water.
Okay, not good.
Bad enough.
Yeah.
Right.
Right.
But then sparks from some welding work at a nearby wharf ignited the oil, causing a massive fire.
Whoa, so the oil spill was bad, but the fire is a whole other level.
A whole other level.
Of disaster.
Exactly.
And that seems pretty far removed. Like, you spilled some oil, but now there's this huge fire.
Yeah, and that was the argument.
Okay.
The court ultimately decided that while the damage from the oil itself was foreseeable, the fire was not. He said a reasonable person wouldn't have predicted that oil on a water could be ignited so easily.
Right.
And lead to that kind of damage.
So even though the oil spill kind of set the stage, the fire damage was just too remote.
It was too remote to hold the ship owners liable.
Okay, so that's what the Wagon Mound test is all about.
That's exactly it. The type of harm has to be reasonably foreseeable.
Okay.
At the time of that breach of duty.
So it's about drawing a line in the sand.
Yes, drawing a line in the sand.
Saying, this far and no further?
Exactly. This far and no further.
Okay.
You're responsible for the things that a reasonable person could predict.
Right.
But not for these bizarre, unpredictable outcomes.
Okay, it's a delicate balance, right?
It is a delicate balance.
Between holding people accountable,
right,
but also recognizing that sometimes truly bizarre things happen.
Absolutely.
And we can't hold people responsible for everything.
No, it would be unfair to do that.
Right.
Yeah.
Okay, so what about those situations where the person harmed had a pre-existing condition that made the harm worse than it might have been for someone else?
This is where the eggshell skull rule comes in.
Right, the eggshell skull rule. I've heard of that before, I admit. The name always throws me off a little bit.
It is a bit of a strange name, isn't it?
It is, yeah.
Eggshell skull.
It makes me think of somebody with like a super fragile skull.
Yeah, it conjures up those images, but the concept is actually pretty important.
Okay.
The eggshell skull rule basically means you take your victim as you find them.
Okay.
So if someone has a pre-existing condition that makes them more susceptible to harm, you're still responsible for the full extent of the damage they suffer.
Okay.
Even if it's more severe than you might expect for, you know, an average person.
So, well, there are already a bit broken excuses allowed.
No, absolutely not.
Okay, good.
You take your victim as you find them.
So is there like a classic case that kind of illustrates this?
There is, yeah. Smith v. Leach, Brain & Co.
Okay.
It's a great example of this rule in action.
Okay.
So the claimant in this case suffered a burn on his lip.
Okay.
Due to the defendant's negligence. Tragically, the burn triggered a pre-existing cancerous condition.
Wow.
Which ultimately led to his death.
Oh, so the burn was the initial harm.
Mm-hmm.
But the pre-existing condition made the consequences much more serious than anyone could have anticipated.
Yes, but the court held that the defendant was still liable for the full extent of the harm.
Wow. So they were liable for his death.
They were liable for his death.
Even though it wasn't, you know, directly caused by the burn itself?
Right, but because of this eggshell skull rule.
Right, because they had to take the victim as they found him.
Exactly. Pre-existing condition and all.
That's a really powerful statement, I think, about responsibility.
It is.
Like, it's saying you can't escape the consequences of your actions just because somebody happened to be more vulnerable.
Right. You can't use someone's inherent vulnerability as a shield against your own liability.
Okay. I mean, it's fascinating how the law tries to account for this, right? These variations in, you know, how susceptible we are to harm.
It's a real challenge, isn't it?
It is, yeah. And I feel like every case we've talked about just shows like another layer of complexity when it comes to this.
It's complex. It's nuanced.
Okay, so we've covered, you know, factual causation. We've covered legal causation, remoteness.
Yes.
The eggshell skull rule. What else is there?
Well, we still need to talk about novus actus interveniens.
Novus actus interveniens.
Which is essentially a new intervening act
okay.
that can break the chain of causation.
So are we talking about, like, you know, I may have left the door unlocked, but I'm not responsible for the fact that a meteor came crashing through the roof while I was out?
Well, a meteor might be pushing it a bit.
Okay, yeah.
In terms of foreseeability.
Right, right.
But you've got the right idea.
Okay.
It's all about, is this new act so unexpected and so powerful that it essentially absolves the original defendant of responsibility?
Okay, let's get into some examples, because I'm already intrigued.
All right, let's do it next.
All right, you were going to tell me about these new intervening act situations.
Right, yeah, where something happens.
Yeah.
That kind of changes the whole story.
Right, and it really shakes up who's ultimately responsible.
It really does.
For the harm.
Yeah, it often involves, like, a lot of legal wrangling over who's really to blame.
Do you have a good case example that kind of illustrates this?
Yeah, Knightley v. Johns is a good one.
Knightley v. Johns, okay.
This case involved a car accident in a tunnel.
Okay.
And a police inspector arrived at the scene.
Right.
But he made a pretty serious mistake.
Oh, no.
He forgot that it was a one-way tunnel.
Oh.
And he sent one of his officers against the flow of traffic.
Oh, no. That's a recipe for disaster.
Yeah, to close off the entrance to the tunnel.
Okay.
So this officer, following his inspector's instructions, collided with another vehicle and was injured.
Okay, so the question then becomes, I guess, who's liable for the officer's injuries?
Exactly. The driver who caused the initial accident?
Right.
Or the inspector who gave this negligent order?
Yeah, it seems pretty clear that, like, the inspector's actions were reckless
Yeah.
and directly led to this, right?
Yeah, and the court agreed in this case.
Okay.
They said the inspector's negligence was a novus actus interveniens.
Right.
So a new intervening act that broke the chain of causation,
Okay.
leading back to the driver of the first accident.
So the initial driver's off the hook because the inspector's actions were so outside the realm.
They were so unforeseeable and so reckless.
It's like, okay, that's on you now.
Yeah, his negligence essentially superseded
Wow.
the original driver's negligence.
Okay, but it's not always that straightforward, is it?
No, it's not. Let's take a look at McHugh v. Holland in Hannon and Cubits, Scotland.
Right.
This case involved a worker who'd suffered a leg injury at work due to his employer's negligence.
Okay.
Later, he was descending a steep staircase
Okay.
without a handrail,
All right.
and his injured leg gave way. He panicked and jumped down the remaining stairs, breaking his ankle.
Okay, so we have the original negligence, the workplace injury, but then the claimant's own actions
Right,
kind of further contributed to the harm.
right. So did they find the employer liable
Right.
for the broken ankle as well?
Yeah, what did they say?
In this case, no.
Okay.
The court said that the claimant's decision to jump down the stairs
Right.
was a novus actus
Okay.
that broke the chain of causation.
So even though, like, the workplace injury made him more vulnerable,
Yes.
they said, well, you shouldn't have jumped.
Essentially, yes.
Right.
They said his actions were unreasonable,
Okay.
given his injury, and therefore the employer was not liable.
Interesting.
So it kind of serves as a reminder
Yeah.
that, while we have this eggshell skull rule,
Right.
claimants also have a responsibility
To not make it worse.
to act reasonably
Yeah.
and try to mitigate further harm.
Okay.
And if they don't, their actions can be seen as a break in the chain.
So it's not always one-sided
No, it's not.
causation, right?
It's really about understanding
Yeah.
the interplay of actions and consequences.
Right.
And how different choices
Yeah.
made by different people
Yeah.
can impact the final outcome.
Right. It's a shared responsibility in some cases.
Yeah, you could say that.
Yeah. Okay, well, this has been,
A lot to think about.
yeah, it's been a really fascinating deep dive. And, I feel like I have a much better grasp now of these legal principles
Good.
and kind of the challenges that courts face.
Yeah, applying these principles in the real world.
Exactly, in the real world, yeah.
Yeah.
But what I find, like, really thought-provoking about all of this is how these cases really force us to think about these questions of responsibility.
Yeah, and fairness.
Fairness, exactly.
What does it mean to cause harm?
Yeah, what does it really mean to cause harm?
It's not just about legal definitions.
Right.
It's about grappling with these ethical dilemmas.
Yeah.
Understanding how our choices have consequences.
Right. And sometimes those consequences
Yeah.
are unpredictable.
They're unpredictable, yeah.
Right. It's a very complex world out there.
It is. It is.
Well, thank you so much for walking me through this.
You're very welcome.
I feel like I've learned a lot.
Good. I'm glad.
And for those of you listening out there,
Yes.
hopefully this has kind of sparked your own legal curiosity.
Keep those legal brains buzzing.
Exactly. Keep those legal brains buzzing. And we'll catch you next time for another deep dive into the fascinating world of law.
See you then.